Robert Myers. My name's Robert Myers, and I'm a partner at Weiss Serota. I've been here for 9 years. And before that, I was the director of the Miami-Dade Commission on Ethics and Public Trust. And we're really happy to be hosting or co-hosting this seminar on government and social media communications, legal and ethical considerations. Also co-hosting with us is the Miami-Dade Commission on Ethics and Public Trust, and its director, Jose Rojo, is one of our panelists. We have a very esteemed panel. I want to introduce them and then go over some housekeeping issues and then turn it over to our first speaker. The first speaker is the Honorable Oliver Gilbert, and he is currently the mayor of Miami Gardens and has been in that position since 2012. For those of you who are not familiar with Miami Gardens, it's the home of the Hard Rock Stadium where the Miami Dolphins play. Mayor Gilbert is going to be embarking on a new career. He is going to be a member of the county commission, sworn in on November 17th of this year. So we wish him well in those endeavors. His topic is going to be the use of social media by elected officials, concerns and potential problems, and social media as sort of, messaging and a way to reach out to constituents. Our second speaker is Abby Corbett, who's a partner at Stearns Weaver, and she is an expert in the First Amendment. And she's also involved in co-counseling case with Weiss Serota, involving in gun litigation and preemption issues. Our third speaker is Jose Rojo, who I sort of alluded to earlier when I started, he is the executive director of the Miami-Dade Commission on Ethics and Public Trust. He's been in that position for 2 years. Before that, he had a long and distinguished career with the Miami-Dade State Attorney's Office and held a number of very high-level positions. He's going to be speaking about ethical issues and enforcement issues when using social media. I should mention that Abby's focus in her presentation is social media communications and the First Amendment. And then lastly, I will speak about open meeting laws and social media communications, specifically speaking on sunshine and public records, if time permits. So just in terms of formatting, Mayor Gilbert is going to speak first, and he's not going to be able to stay throughout the entire 2 hours. So he's going to speak first. So if you have any questions for Mayor Gilbert, you will notice that there is a Q&A button. So just press that Q&A button and we will see your questions. And at the end of the mayor's presentation, he will respond to any questions that you have. For the rest of us, please hold your questions until we're done with our presentation. So you can jot your question down as we're speaking, but we won't get to your questions until the end of I guess the fourth presentation, which would be mine. We are recording this. Three of us are doing PowerPoint presentations. So if you want copies of the presentation, just let us know and we will make sure that you receive them. We can email them to you. We are applying for CLE credits for the lawyers in the audience. So, when we do get the credit, we will pass that information along if you let us know that you're interested in such, such credit. And I know we'll be able to get some ethics hours, which is always a big deal for the lawyers. So like I say, your role in part is to listen, but also to participate in the sense of you can ask questions, like I say, just to press the Q&A button. I would prefer that the questions are relevant, to the topic at hand. Personal comments about, oh, Myers, I haven't seen you in a long time. You've gained weight and lost a lot of hair. Those things are not relevant. I'm not going to answer those questions, but we will address as many questions as we can in the time permitting. If there are questions that we can't get to because we run out of time, send them to us anyway, and one of us probably can reach out to you with a response. So without further ado, I'd like to turn this over to Mayor Gilbert. Mayor Gilbert, the floor is yours.
Thank you, Robert. Hello, Abby. Hello, Jose, and to everyone who's out there listening. And Robert, let me just say, you lost a little weight, and you look like your hair is coming back. You look absolutely wonderful. I mean, and I think that's completely relevant to ethics. Everything I just said is relevant to sunshine. The sun is shining on you. I promise. I'm Oliver Gilbert, and let me just also say that, you know, I'm a former attorney at Weiss Serota, and so let me thank them for being a part of this. Let me thank them for inviting me. This is an interesting topic because it's completely relevant to exactly how we live our lives now, and it's actually highlighted by the fact that we're going through the COVID-19 crisis, because we forced ourselves to actually communicate more electronically, communicate more through social media. We're using those things more, even as a government, not just elected officials, to actually get information out. You know, it's interesting when we start to really think about when I think about being an elected official and social media, what really pops up first in my head is that first, social media is actually the new word of mouth now. So, and that's what you're actually always trying to create. You're trying to create something that doesn't just exist on your page. It doesn't just exist on your Instagram account. It's just not on your Twitter. You're trying to get retweeted. You're trying to get that post share. You're trying to create, you're trying to get the people who see your message to see it and then amplify it. And it allows that to be done in a very, very, very unique way. There's this fine balance that I think that we have to do. And I think that it's probably going to be, it's already the subject of litigation. It'll be the subject of more litigation. It is the distinction between creating a public persona and actually doing city and official government business. What I try to do as an elected official isn't necessarily do public business. So, and I think that if you pay attention to different elected officials and their social media accounts, you'll see what looks like business but isn't. You'll see pictures of food giveaways, and you'll see pictures of people visiting schools. That's a far cry from talking about whether schools should actually be open from a policy perspective. And so what we're always trying to do is communicate in a way that shows the public what we're doing. And when you're running for office, it shows the public what you're doing and actually soliciting them to actually be a part of that, to join your team, whether it's financially, whether it's a vote, whether it's volunteering, but not necessarily create, I'm not trying to create a message board for ideas with respect to us going back and forth about policy. Because I do believe that when you get into a situation like that, if you invite it and you're creating that type of message board, and that's the forum, I think that you have to maintain that median and those records in the way that you would have to maintain other stuff, as though it was actually in the city. And so I think that's very dangerous, and I'm always clear not to do it, but I think that there is a way for us to allow the public in to see who we are when we're not sitting behind a desk or in a bow tie or doing a webinar or giving a speech, but when we're just out there with kids on parks, when we're just out there helping senior citizens, when we're just out there, you know, exhibiting who we are as individuals, and let that picture, let that voice, let that image be amplified in a way that actually gets people to believe in you as a person. And so I think that's generally how I feel about social media. I think one of the problems that you have is when you're out there, it's hard to separate Oliver, the man and the father, from Oliver, the mayor and the commissioner-elect. And so, like, for instance, you'll see people you'll always get people who, even though every Facebook will give an account to apparently anybody, even Russians, they will, sorry, Robert, I had to make a joke. The people feel the need to try to impose their opinions on your page and how you balance that. So you'll have things like my son's graduation, and I'll post, hey, this is a picture of me and my son, and someone says something really rude and really nasty in the comments. And then they're surprised when their comment gets deleted. And then they want to know, well, legally, can you delete my comment? Well, yeah, the fact that I'm a public official, I actually have a public figure page. I also have a personal page. And the post was that of a personal nature. And so me being a mayor doesn't change me being a man. It doesn't change me being a father. It doesn't change who I am personally. And you don't necessarily have the right to comment on every part of my life. You clearly don't have the right to actually impose on that post something that has nothing to do with it. And so finding the balance between, you know, allowing for that type of discourse in public and providing for that type of discourse in public, but also having the ability to do what everyone else does. And I like to remind people that when you're an elected official, there's this thing which we give up certain amenities that people take for granted. So I understand that I don't enjoy anonymity. If I wanted anonymity, I wouldn't have put my face on billboards and on televisions, and I wouldn't have been in the news. So I wanted anonymity. But while I gave up anonymity, I don't necessarily relinquish the other rights that everyone else on all of those social media outlets have. I don't relinquish the right to post about my kid or my relationship without you telling me about your red light camera ticket. I don't relinquish that. So I know that there are going to be lawsuits and there are, but that can get you deleted. And so, and that's a whole nother thing, whether you should be able to actually delete or block people from your social media. If your social media is personal and you're not doing city business and you're not doing official business, then I believe that you have the right to block people as just like everyone else would, with the understanding that their speech isn't being restricted because they still have their Facebook page. They still have their Twitter account. They still have their Instagram account. They can still Snapchat all they want. They just can't talk about it on your post of your son's graduation. And so, but finding those balances is what we're gonna have to find together. So many people like Abby and like Jose and like Robert, like the wonderful lawyers at Weiss Sirota, who are gonna actually help us do that. Because this is new water for us. This is new ocean. This is how we cross it, the path across. We don't really know. When you live in a society that honors and respects expression and speech as much as we do, and we have to find a way to allow for that speech, but also be protective of people's rights. And so that is generally how I see social media. I would love to have any questions if there are any questions about it. And if you're out there, you can follow me at ogilbert3 on Instagram, and you can follow me at ogilbert on Twitter, and you can follow me at Oliver Gilbert on Facebook. Thank you. Wait, there are 2 questions.
Mayor Gilbert, there is a question for you if you want to answer it.
Okay.
Can you read the question?
I'm looking at, I am a municipal lawyer, and have an ethics question. Donating personally to an election campaign of officials who serve municipalities that our law firm represents, unsolicited donations. I have more than one friend now, public candidate with friendships decades older than law relationships. So if the question is, can you donate? I think it's going to be based on the municipal code. So like in our code in Miami Gardens, we don't allow vendors to make political contributions to candidates who are running in Miami Gardens. And so, but now let me just say this. I don't challenge that for Miami Gardens. We abide by it for Miami Gardens. I'm not completely sure after Citizens United and all the other court cases that type of prohibition is still actually legal.
I agree.
I just think no one's actually challenged it. I think that if someone actually challenged prohibitions like that, I think that they would have to be removed. At this point in this country, we've come to the idea that pure money, a lot of money is still pure speech, and you can give it, and you can give it to whomever and basically however you want to, with very little restrictions. So I don't know that they're still legal, but I think that you're being a lawyer, I think that it's incumbent on you to actually look at those cities, those positions, and see what they allow for. I'm a lawyer, and so when raising money to run for re-election in Miami Gardens, and then when raising money to run for election in county commission, a lot of lawyers gave me money. That's because that's my peer group. So those are the people I practiced with for years. Some people gave me money, never gave me money for county commission, well, for mayor of Miami Gardens, but they gave me money for county commission just because of that prohibition. So I would just ask you to look at those different prohibitions and go from there. Let's see, we have other questions. Is the Facebook page titled differently? Okay, is the Facebook page titled differently? And for instance, if the page has mayor and official town email in it, Okay, my Facebook page does not have mayor in it. Now, I know a lot of people have mayor on their Facebook pages, or they put their title on their Facebook pages. I always thought that your Facebook page, when they said put your name, my name is Oliver Gilbert. So that was my name. My parents gave it to me. It'll be my name long after I'm the mayor of Miami Gardens. And so I just put my name there. I don't include my title on my Facebook page at all. And it isn't linked to any city email. So, and that's the truth for my public page, my public figure page. I do have a public figure page, and I have a personal Facebook page. So that was the question from Ilanya. And then anonymous attendee, what happens when the public page becomes a campaign page? Does the public comment, public forum requirement change? I still think it's substantive as regards to what's being posted. And because your public figure page is not necessarily a non-campaign page. Just because someone's a public figure doesn't mean they're actually doing official business. So your public figure page can still just show with you and kids and parks and puppies and law enforcement and military. You don't have to be talking about the zoning ordinance on your public page. So I think you really have to look at the content and how it's being used, and not just whether they're a public figure. Remember, just being a public figure does not transition the community, doesn't bring in the requirements of law on that communication. So it won't, the record retention requirements and all of those things from my perspective don't apply just because it's a public figure page. Now, cities will actually have.
Can I ask you a question about Facebook?
Sure.
Sure. So Facebook apparently now has, they have a public official page and a candidate page. So why do you think Facebook, I mean, if any, and Abby or Jose, if they want to respond, why do you think they create that separation between the two pages?
I think it's because they just recognize what I just said, that you can be a public figure, right, and that's not necessarily the same as being a candidate, and not every candidate is a public figure already. They're putting themselves in a position to be notarized, to be noted by the public, but they're not necessarily there yet. So I think that distinction is actually important. And I think that when you have people who are running for office, I think that you have to allow for a wider berth of speech. So I won't agree with a lot of things that a lot of people say when they're running for office, but I think if these are your ideas and you're putting your ideas into the marketplace of ideas and you're asking people essentially to buy into it and to elect you, I think that even if I find your ideas offensive, I think that if you're a candidate and you are running for office, you should virtually be able to say anything on those social media sites because you're a candidate and you're looking for that constituency. And that information, and I know that some people won't actually like that, and I won't like some of the things that are said, but that's not the barometer of whether we should allow it or not, whether I like it. So that's not the barometer. So I think that's Facebook actually acknowledging those distinctions. Somebody asked the question, what are your thoughts about being harassed? If you're harassing me, I probably will block you. So if you're being like the type of comments that we wouldn't allow if you were standing in my city council meeting, if you were standing in my city council meeting and you were cursing something, you might, when you look at my Facebook page, I'm never negative. I'm never negative. And if you're going to be negative or nasty, not even towards me, like when I was running for office, people would say things about my opponent. I would just take it down. And then some people would repost it and I would take it down again. If they reposted it a third time, I would just block you from my page. You're not going to be nasty with anybody on my page. You're not going to curse at anybody on my page. The same way I wouldn't let you have impertinent remarks if you were standing in the city council meeting with your 2 minutes in public comment, you're not going to do it on my page. And so I feel like if we have that standard for a city meeting where the public records and sunshine and all those things definitely apply, we can definitely have those standards on my personal page when it probably doesn't apply. But I'm not going to let you attack people endlessly. You don't have to agree with me. You don't have to tell me my tie looks good. You don't do any of that stuff. But I've had people make racial remarks. I've had people make homophobic remarks, anti-Semitic remarks, and I just cannot have that functionally under my name. I will not have that under my that will not exist. So I know there's a difference in whether we can prohibit that on the city's pages, on the city's accounts. And so we can talk about that from a city perspective, but from a personal perspective, if you're making anti-Semitic remarks on my page, you're not going to be on my page. And so, and if you think that the remedy to you not being on my page, if it really is that important to you, you can sue and we all have lawyers. But that's not something that I can actually allow for. And if I'm going to allow for that, I'm going to need a judge to explain it to me. Like personally, like the judge has to sit me down and say, well, Oliver, this is why it has to happen this way. because otherwise I'm not going to let my page and my popularity be a vehicle for hate ever. Nastiness, disrespect, ever. It's just not going to happen.
You have time for a few more, Mr. Mayor?
Yeah, I'm scrolling down. Yeah, I appreciate Maggie Fernandez, the county attorney, opined that elected officials and staff are not allowed to block even on personal. I just think they're wrong. I think they're wrong. I think that's a safe answer, but I think that they're wrong. And I appreciate that they're county attorneys. I took the same bar exam. So it's, you know, I'm going to go ahead and go with my opinion on that. So I think that we've taken a position now that doesn't allow for the nuance of how we live and what social media is. Social media, you know, the difference between me and my page where I'm doing all of my personal stuff, to say that I could not block somebody, that's like saying that you can't have a private page. Because all private pages is blocking everybody and letting selected people in. So unless the county attorney is going to say that no elected official can have a private page,
yeah,
then their line of reasoning doesn't, when you start extrapolating out, it just doesn't work. So I can appreciate what their answer is, and I'm sure that I'll lean on their advice after November 17th. But right now, I'm just going to try it a different way. When can I block someone on a public page or campaign? How do I know if I have created a public forum? I think you'll know how you create a public forum based on the content that you're posting. So if you're posting, like I'm posting food giveaways, pictures of food giveaways. I'm not posting necessarily whether we should be having food giveaways. You know, I'll show pictures of us ribbon cutting. I'm not actually talking about the zoning changes that actually made the ribbon cuttings possible. I'm not doing those things. So there's a difference between advertising things that have happened and the creation of public forum. And while they both might seem like a part of the same thing, I think that there's definitely some requirements. You definitely have created a public forum when you start talking about ideas and stuff that's going to come before you as an elected official, and as opposed to advertising something that's happened previously. What if it's set up as a governmental organization? If it's set up as a governmental organization, I think it's going to be different rules that apply.
And there's a question about the Sunshine Law. If you want to,
where
anonymous attendee, do you see that one? I mean, I can take it.
How do you prevent a Sunshine Law violation on a public page or virtual Facebook town hall? Can one board member speak to another? No, you can't speak to another person. You can't speak to each other on those pages. I don't know that any of my colleagues are actually on my page. I avoid it by actually not having the conversations about stuff generally that's going to be voted on. So it really doesn't matter who's having the conversations, because I'm not, from a content perspective, I'm not talking about things that are going to be voted on. But remember that you can say something. So one person saying something and another elected official hearing it is not in and of itself a sunshine violation. It's the actual conversation. And so avoiding that back and forth. And that's going to be incumbent on the wonderful training that Jose and the folks at the commission do. They tell us we can't do that. And so we know we can't do that. And so if someone did it from my perspective, I think that, well, the first thing you would do is you would be immediately required to disclose, but you'd also be required to maintain that as a document. So you have to get it to the printing out or storing it or backing up somehow, but I think that you'd have to maintain it at that point.
Very good. Mr. Mayor, we thank you for your comments. You're erudite and articulate, and explained exactly how Sunshine Law can be of great value in the 21st century. And we wish you well as a county commissioner. So thank you very much for being part of the program.
No, thank you all very much. And Jose, I hope I didn't say anything that I got messed up. Listen, I don't. Thank you. Peace. All right, y'all have a good day now. Thank y'all for inviting me.
And for those of you who have additional questions, I mean, for the mayor, we can try to answer them at the end of the seminar. So let me turn it over now to Abby Corbett, who's going to speak about the First Amendment and social media. communications, and it dovetails very nicely into some of the remarks by the mayor. Abby?
Dovetails perfectly, yes. Thank you so much. A lot of those questions you guys had and a lot of the mayor's remarks are exactly what I'm going to be talking about. So after I'm done, and I guess after Jose and Robert are also done, there'll be an opportunity for questions about this, but some of you guys are already on the right track. So I advise local governments on constitutional issues, including First Amendment issues, and I also litigate constitutional issues. And I get increasingly every year more and more questions about the First Amendment as it applies in social media. And I get the questions I get basically fall into two categories. So I'm going to break my remarks up into those two types because basically different legal principles apply. The first is when public employees or public officials are using social media personally in their personal capacity. And I'll explain what the relevant legal standards are there, give some real world examples from the case law and otherwise, and then explain what some best practices are for your agency if you don't already have policies in place. And then the other category is when public entities are using their own official social media page. And as we've already seen, sometimes the line between these two things is exactly where the root of the matter is. But when you have official governmental social media pages, a different set of legal standards applies. And I'll give you some examples of that from the case law. And then I'll explain what some suggested good policies are to have in that arena. So first, does the First Amendment protect personal social media activity by public employees? Typical lawyer answer, it depends. But yes, oftentimes it does, but it's a highly fact-specific inquiry. And the case law, if you're looking for an area where the case law is black and white, you came to the wrong topic. The case law is, there are general principles that are applied, but there's a lot of inconsistency. I think that that's because judges and law clerks nerd out when they get these kinds of cases. It's why they went to law school. They get excited about it and they write these really long opinions that sometimes are internally inconsistent or results oriented. And that's okay though, because fortunately the US Supreme Court has provided some guidelines, as you'll see. And basically they boil down to, you have to examine the content of the statements at issue, all the surrounding circumstances, what the impact the statement had on the employer, and the nature of that employee's job, which can very much influence what the impact was. So the main analysis here, the legal rubric is Pickering-Connick Balancing analysis. A lot of lawyers call it the balancing test. I don't like that phrase because it sounds like you just input some facts and it spits out the answer. It's not that clear cut. I think analysis is the better term. The Pickering came from a 1968 US Supreme Court case where a public school teacher was critical in a letter to the editor of the way the school board was allocating public funds. And the court said that was protected speech. And in making that ruling, Justice Thurgood Marshall wrote, I think, the most important sentence in this area of law, so I'll just read it to you. The problem in any case is to arrive at a balance between the interest of the teacher as a citizen in commenting on matters of public concern, and on the other hand, the interest of the state as an employer in promoting the efficiency of the public services that it performs through its employees. So that, in a nutshell, is that balancing analysis. The term Connick comes from a case from the 1980s. The New Orleans DA, Harriet Connick Sr., actually Harriet Connick Jr.'s father, had fired an assistant DA who was distributing his questionnaire at work that was critical of their internal office policies. It was a close call, but the Supreme Court 5-4 said, not protected speech. This was about an internal office policy. This was not about a matter of public concern. And as you can imagine, that can be a close call as to whether something rises to that level or if it's more of an internal dispute. I came up with this graph, maybe a little overly simplistic, but I think it's helpful. Were the statements at issue about a matter of public concern? If not, there's likely no First Amendment protection. If they are, you have to balance the employee's free speech interest with the employer's interest in a disruption-free, efficiently run workplace. And when I say balancing, it's literally an evidentiary inquiry. So at summary judgment or trial, if this goes to court, you need evidence, you need affidavits, you need testimony showing that there's been a disruption. There's the Garcetti exception that gets a lot of attention, and the facts are super interesting. It went up to the US Supreme Court as well. There, a DA drafted an internal memo that was basically blowing the whistle on the fact that he didn't believe the affidavit in support of a search warrant for his case was true. He raised it, but he was kind of ignored, and then he testified for the defense at the case. He was passed up for promotion. He said that violates my First Amendment rights because I was speaking at the time I was testifying for the defense. The court said, no, you are making those public statements pursuant to your official duties. So granted, he wasn't necessarily saying what his employer wanted him to say, but he was doing his job at the time. The words coming out of his mouth were while he was acting as a DA. This doesn't come up a lot in the online speech social media cases, unless we're talking about speech that folks are doing on the official pages, or maybe sometimes elected officials might be close to this line. But this isn't so much one that applies when you just have a regular employee making comments on their personal page or someone else's personal page in their personal capacity. And it also has a very important limitation. So this exception only applies to speech made pursuant to your official duties, like that DA doing his job, not just speech about your work. So really good example of this case was another US Supreme Court case where a college administrator had testified about financial improprieties at the university. So unlike the DA who was testifying as part of his job, this college administrator was testifying because he'd been subpoenaed essentially as a regular citizen, but what he was testifying about happened to be financial improprieties at the public university. And the court held that was protected speech. Justice Sotomayor summed this up very nicely. She said, truthful testimony under oath by a public employee outside the scope of his ordinary job duties is speech as a citizen, even if it relates to the employment or concerns information learned during the employment. I think that's a really important distinction. What about voting by elected officials? So this is a super interesting concept. Most of the cases you've seen so far, and we'll see in the rest of my presentation, involve staff, because staff are folks that will sometimes be terminated or demoted or passed up for promotion, whereas elected officials are usually held to account by the voters. So that doesn't arise, First Amendment litigation usually doesn't arise, but there are exceptions. And one is in the context of elected officials casting their vote. So US Supreme Court addressed this question in 2011 in the Kerrigan case. And there was a city council member who had been reprimanded by an ethics commission for voting when he had a conflict of interest. And he said, this sanctioning violates my First Amendment rights because I was expressing myself when I cast that vote. And the court said no, no First Amendment protection for the casting of your vote. And the majority, as is true of most of these cases, by the way, the concurrence will phrase it differently than the majority, and maybe there'll be some dissents, but here the majority's logic was kind of twofold. One is when a legislator casts their vote, they're not expressing their own personal views. They're deemed to be expressing the view of their constituents. Now, it may be, if you're an elected official, that you're oftentimes voting, hopefully for your sake, you're oftentimes getting to vote the way you also feel as well as your constituents. But sometimes maybe you don't. Sometimes maybe you voice what you believe your constituents want, but that really doesn't matter for this analysis. Either way, you're deemed to be expressing your constituents' opinions. And then the court said, even if that weren't true, even if we were to accept that to a certain extent you're also expressing your own view, prior Supreme Court case law had held that you can't use governmental mechanics to convey a personal message. That's not within your job description to do. That's a super interesting and relatively unusual case in that it directly involved elected officials. By the way, the result here probably might have been different. The analysis certainly would have to be different if this were a city council member who was somehow sanctioned for words he or she had used about the vote, whether it be from the dais, on a social media page, or otherwise. That would be a whole separate analysis that arguably would fall under the Pickering-Connick test, although there are some courts that say you don't really use that analysis for elected officials, but it really doesn't come up very often anyway, so we don't really know how that would play out. All right, now I'll give you a couple examples of more recent cases that are in the social media context, because of course all those cases are more recent in time because of the development of the technology, but the principles are the same. So the Pickering-Connick analysis with all of its caveats and exceptions is the general rubric that you're gonna look at. This case, federal court in Tennessee from last year, is an interesting one because Mr. Goza was a technician for a public utility company, and he made some very racially offensive Facebook posts. I'm not going to share them with you guys because I don't think we should be just distributing those comments, but suffice it to say they were offensive posts. And he also had made racially offensive comments to a news media at a rally. And he was fired, and he got his job back because of the First Amendment. So the headlines, when this story came out, when this ruling came out, were he made these terrible comments and he got his job back, but that's not really the heart of the story. The thing to look for is the fact that the defendant didn't present evidence of disruption. So, and I don't know if it was that they couldn't present evidence of disruption or they just didn't, but that's why that case turned out the way it did. The level of offensiveness of the comment was less important in the case than the fact that there was not evidence of disruption. Now, proving the disruption, it'll be easier to prove disruption if if a post goes viral and all of your coworkers see that and all of the members of the public, like this technician, the case mentions, had interacted with a lot of the public. So if they had maybe talked to some of those people in the public and they had seen the post, that would possibly amount to disruption of his ability to do his job effectively. But we don't know exactly how that played out. One special consideration that comes up a lot in these cases is a slightly different, it's not really a different standard, but you'll see it play out differently, these cases, in the context of law enforcement. And the Seventh Circuit did a good job of explaining why that is. And it's that the courts deem law enforcement employers, that's law enforcement agencies, to have sort of a heightened interest in unit cohesion, fostering positive relationships with the public, et cetera. So the standard isn't really different, but the ability to show that impact on disruption of the workplace is sometimes a lot easier when it comes to law enforcement. The Seventh Circuit said that's because there's an urgent need for close teamwork among those involved in the high stakes field of law enforcement. So some examples of where that plays out, the Second Circuit in 2002 upheld the termination of some police officers who disseminated racially offensive materials. That actually wasn't on social media, but the officer in his own time mailed from his house racially offensive flyers, and disruption was deemed to be proven in that case. The Phillips case from the Fourth Circuit is interesting because not only does it involve police officers, it involved a police chief, and this is another important area of the law. It was a police chief who criticized the town council. So something that probably comes up fairly often, and this is a high-level employee. So the important quote from that case is that a public employee who has a confidential policymaking or public contact role and then speaks out in a way that interferes with or undermines the operation of the agency, its mission, or public confidence, enjoys substantially less First Amendment protection than does a lower level employee. And that substantially less is exactly the kind of phrasing you'll see in all these cases. Nothing is clear cut. It's all, a little bit more or a little bit less, but it's still an important thing to keep in mind when you're trying to figure out what action you can or should take. So a good example of a policy, an SOP on this topic that was too broad came out of Petersburg, Virginia, from the police department. And the language there, the most relevant language, said negative comments on the internal operations of the Bureau or specific conduct of supervisors or peers that impacts the public's perception of the department is not protected by the First Amendment, end quote. So pro tip, anytime you see somebody say, this is not protected by the First Amendment, or this is protected by the First Amendment, might be a hint that they're going a little too far because these things are so fact specific. Sure enough, it was challenged. There were 2 veteran police officers who were punished for making a number of Facebook posts and comments that were critical of the promotion of younger officers over more seasoned officers to be instructors. And it's certainly probably a matter of public concern. The average person might want to know whether the officers in their community are properly trained or not. But ultimately, the court didn't get to that question. The court remanded it, the appellate court remanded it back to the district court, and the parties settled before the balancing was done. But the important part about this case is the Fourth Circuit said, yeah, that language is just too broad. It's too speculative. It chills some speech that would be protected under some circumstances, the way it's worded. So it's not just law enforcement who might have this less protection. It's not just senior policymakers either. It can also be first responders, teachers, depending on the circumstances. So in one case, the Second Circuit upheld the termination of firefighters who rode on racially offensive parade floats, and there did seem to be this extra credence that was given to the employer in that situation because they were firefighters. This Carlton case, the Sixth Circuit just decided this year, is super interesting. There, an EMS worker had made comments on social media about the death of Tamir Rice, who, as most of you probably know, is the unarmed Black boy who was killed by police officers a number of years ago. And the trial court believed that the comments of the EMS worker were of a private interest nature, not of a public interest. And the reason they thought that is that the way the comments were phrased was by the EMS worker was basically, if I were there or if somebody I loved was in this park, they would have felt threatened by this young man. I'm glad the police officers did what they did. So the trial court thought, well, maybe this is more about this guy's expressing his opinion about himself. But the appellate court said, no, that's still a comment. Even if you phrase it as about you, it's still a comment about the death of Tamir Rice. So it's been remanded on the question of balancing whether there was in fact an impact, but it's potentially protected speech because it was in fact a matter of public concern. An example of a teacher case, and this is public school, public universities is like a whole separate thing for another webinar, but when it comes to regular public school teachers, the high school level and below, sometimes you'll see this happen as well. So Georgia Supreme Court decided this case a couple of years ago. There was a teacher at a public school in Georgia who was suspended for posting something on Facebook that was critical of Black Lives Matter. And the suspension was upheld. The officials who suspended her were deemed to have qualified immunity because evidence was presented that her post interfered with the operation of the middle school where she taught. So what are some best practices that you can implement in light of all this for your employees' own social media use? First, have a well-considered, well-vetted written social media policy. It should go through your First Amendment counsel or somebody in-house who's an expert on the First Amendment, as well as labor and employment lawyers. Some examples of policies you can have in there, and this will really depend on the nature of your agency and the rest of the provisions you have in your policy, as well as your litigation risk comfort level. But I do think you can warn employees that to the extent they engage in conduct online that affects their job performance, negatively affects their job performance or that of others, and you can give some examples like harassing statements, revealing confidential information, that might result in disciplinary action, right? You're not saying, don't say anything negative about us, because if so, that's not protected. You're saying, here's some examples of conduct that might negatively affect your job performance, and be on notice that you could be terminated for such conduct. All right, this is a good policy to have in general for numerous reasons. No social media use while you're on duty or when you're using employer provided devices. I realize that's really hard these days with people working from home, but it's still a good policy to have. Another one that can help you and your staff is having disclaimers whenever it's unclear who you're speaking on behalf of. So if you have an employee who has their own page, but maybe either based on the way their page is laid out or based on the content of what they're saying, it might be unclear who they're speaking on behalf of, you can encourage them to use disclaimers. You know, my views do not represent those of my employer. This doesn't solve all problems, but it can sometimes help. All right, now I'm going to talk for a couple of minutes about public entities' own official social media pages. Kind of a separate topic. And as you guys, all the smart people in their questions earlier hinted at, the key question is, have you created a public forum? Sometimes in this context, it's called a digital town hall, and it doesn't have to be a live town hall type Facebook Live thing. It can just be any sort of digital context where you're allowing people to communicate back and forth. If you are deemed to have created a public forum, then most likely selectively interfering with who can communicate based on the content of what they're saying will likely violate their First Amendment rights. So that's why it's such a critical question. And I've heard from some people, but isn't our social media page government speech, which we can regulate? And the answer is yes, sort of. So your page as a whole is arguably government speech, the way that you've laid out, you know, the background information about your organization, and your individual posts are arguably government speech, I believe are government speech. But when you open the comments, that's where the trouble begins. So, and on some social media platforms, most, I believe, comments are sort of default, or the ability to comment is a default setting. But you will still be deemed to have actively gone in there. There's no distinction between whether you enabled comments or comments were automatically enabled. If comments are happening on your page, you potentially have opened a public forum. I do think that there's still arguments to be made, and in certain litigation, I imagine this argument will get made, and like Mayor Gilbert alluded to earlier, this area of law is going to develop. The fact that those comments are still on the local government's page is relevant. I think it does make it seem more like it's part of the government speech, but most of the courts that have seen this issue so far, 2 federal appellate courts, have said that those open comments are a public forum. So I'll give you a couple of those specific examples. Blocking particular users, like we talked about earlier. So if right now, by the way, I'm not talking about Mayor Gilbert's scenario where it's his personal page. I'm talking about this is the city or the county or the state agency's page, okay? So for the sake of this argument, that's what we're talking about. It's definitely the public page. I would discourage you from blocking particular users based on their content. This came up in what looked like it was going to be about a personal page, but ultimately was not from an analytical perspective. So the Second Circuit a couple years ago addressed this question in the context of Donald Trump's Twitter account. So this is the same Twitter account that Donald Trump used before he was president. And then after he became president, he or his staff blocked particular users based on negative comments they had made, and those people sued. And you would think the crux of the debate would be, is this his personal page or not? But he had stipulated previously that those comments, that the tweets that he had made post him being elected president, or at least be inaugurated, were official statements of the president. They go to the Library of Congress. All those tweets are considered official statements of the president. And because of that, it was very hard for him to argue that those particular posts were not, were not in fact government speech that then open comments were open to. So ultimately, the Second Circuit said, yeah, that comment process and then participating in general, and participating, whether not just be commenting, viewing, retweeting, replying to, liking. I'd imagine these people weren't liking very many of them, but all of that was stripped of these people when they were blocked. And the Second Circuit said you cannot do that. What about deleting individual comments? So again, I'm not talking about Mayor Gilbert's personal page. That's a different scenario. But for your governmental agency's official page, can you delete individual comments? Now, there are some scenarios where the individual comment is not protected speech. It's obscenity, it's libel, or it maybe violates the terms and conditions of the social media platform. That would be a separate category. But if you're deleting an individual comment because you don't like the content of the speech because it's politically insensitive or negative, that's probably going to be very problematic. The tricky ones are scenarios like people spamming irrelevant information, people maybe cursing or saying things that are just not family friendly. And that's really where the most interesting cases are going to develop, I think, because you can make the argument that this is our government speech page. We want children to be able to come on here and learn about their city. We don't want them to see all this irrelevant or inappropriate, even if not obscene information. But if you have some sort of argument like that, then talk to your First Amendment counsel and make a judgment call. But if you're deleting individual comments because somebody was critical of that issue that you're posting about, I would seriously avoid doing that. Another question, can you just delete your original post with all the comments if you don't like how the comments are going? This is probably a little cuter and a little less obvious, and maybe even a slightly safer option because you do have some control over your original post. It's government speech. But if it looks like you're deleting that original post in order to get rid of negative comments, that's going to look like content-based restriction on speech, and I think you're going to get a result very similar to what you got in the Trump case from the Second Circuit. Another option, getting kind of farther away from the please don't ever do this, is disabling comments altogether or disabling comments from some post. So sitting here today in 2020, disabling comments from all posts, I think, is probably in most scenarios going to be fairly safe. Now, 50 years from now, when social media is possibly the way people communicate with their government, and you're the only outlier local government that's not allowing people to comment through Facebook, that may be a different story because it may look like you're trying to restrict aggregate speech, even if it's not content-based. But if you wanted to if you have a particular type of page and you're just not intending it to be a public forum and you're consistent about it and you're disabling comments from all the posts, that's something to talk to your counsel about, and they might very well get comfortable with that. If you're disabling comments from some posts, the most relevant question would be why and what posts are they? If you're disabling comments anytime you're talking about what your elected officials are doing because you don't want negative comments, that's going to look more problematic. If you're also still allowing comments on what the public utility is doing or something. So if you had a super consistent and very logical reason why you were doing that didn't look like it was trying to restrict speech, that might be something that you and your counsel can get comfortable with. So here's some examples of best practices in this regard. First, just like with your social media policy for employees, you should have a well-vetted written social media content guidelines and policies document if you don't already. I think those policies should provide that you have social media designees, a couple people on staff, not one because people go on vacation or get sick, but a handful, not an unruly number, but a set number of people who are trained in this area, who understand the kinds of stuff we've just been talking about, who know what they can do and what they can't do in this regard if they get requests from elected officials or if they get requests from the city manager, whoever. But more importantly than knowing what they can and can't do, knowing the giant gray area where they have to call counsel, having a sense of what might be problematic before they do it so that they know to come to somebody and ask for help about making those tricky judgment calls. And lastly, that policy, the guidelines and policies can also cover issues unrelated to this First Amendment issues and should, like public record retention of your social media content, which Robert's going to talk about, and the use of trademarks and copyrights, whether your use on your pages of others or their use of yours. Lots of issues like that can be covered in these guidelines and policies. So that's all I have for right now. And I think a couple questions came in, but I think we're going to save questions for me and Jose until the very end, Robert. Is that right?
Yes, let's do it that way, if you don't mind.
Absolutely.
Okay, well, thank you so much for your very insightful presentation and helping us work through this quagmire. And I'm sure people, who are in your shoes with your expertise, got exciting times ahead of you in the world of law, policy, and social media. So thank you so much. Okay, now let's turn this over to Jose Orojo, as I said earlier, who's the director of the Miami-Dade Commission on Ethics and Public Trust. And he's going to speak to you about ethics-related issues and enforcement with respect to social media communications. So, Jose, the floor is yours.
So I'm trying to see if I can get to the our slide presentation.
We have, I should mention that Linda and Amanda, who work in our office, have been instrumental in putting this together, and they're behind the scenes making sure that this goes off, and it's a lot of work. So now we're relying on them to at least have Linda help us with the slide presentation. Okay, there we go.
Okay. Okay, very good. So good afternoon, and thank you all for staying on. Yeah, I hope everyone can hear me okay. And Robert and Abby asked me to talk to you a little bit about not necessarily whether the speech by the elected official is protected speech, but rather whether public resources are being used as part of producing the social media and getting it out, and whether the speech pertains to local governance, which would be okay or permissible under the ethics code, versus purely political speech or campaign speech. So most of the opinions and scenarios that I'll be talking to you about today really deal during campaign cycles, and we've been in a rather long campaign cycle for the last however many months, and so a lot of the opinions come out of that background where elected officials are making comments in their official capacity about local governance on the one hand, but on the other hand, they're also making comments in support of their candidacy for the current position, if they're incumbent or new positions. So that's what I want to talk about a little bit. So we can go to the next slide, please. Okay. And as you can tell by the title, I mean, we struggle with coming up with that line between what is protected political speech and what is exploitation of public position. I don't believe, at least in my opinion, that it's a bright line. It's going to be a very fact-specific look, and it's often very fuzzy. So next slide. Right, so that is our local county ordinance, and we're going to analyze whether elected officials are improperly using public resources to generate and disseminate social media messaging through our exploitation article, which is section G of the county ethics code, and we really look at it as whether the public employee, the elected official, is using the special privileges of office, to benefit himself politically, or if it's an employee, whether an employee or staffer is using the benefits of public employment, to benefit the elected official's political gains. So next slide, please. All right. And so these are statements that we have issued or have been contained in our previous ethics opinions, and this I'm kind of mimicking in a very broad and certainly not as sophisticated or as informed manner what Abby has told you for during her presentation, right? So that certainly elected officials and to a lesser extent public employees have a protected right to engage in public political speech, but that doesn't mean that they have the right to use local government resources to facilitate this speech. And so this becomes of critical importance when elected officials are communicating with their constituents about local governance, but also responding at the same time to political opponents, during a campaign. And very often it may be the same messaging or very similar messaging, and it's very subtle, right? So, but you still don't have the right to use local government resources for political purposes. Next slide. Okay. So here's a kind of the how we define here in Miami-Dade County what is prohibited conduct under Section G of the ordinance, right? So we would say that if there's no clear municipal or local government purpose served by video, or the video serves, and in this particular case, this was a video that was produced by local government using local government resources and then disseminated, right? So if there's no clear municipal purpose served by the video, or if the video serves to significantly or exclusively highlight the elected official's personal or professional qualifications or accomplishments while in office within the context of a campaign, then I think that the Ethics Commission is going to fall on the side that constitutes prohibited conduct under the exploitation portion of the ordinance, and that you should not be using resources, government resources. And I think that we have some more specific examples of what's significant or exclusively highlighting an elected official's personal or professional qualifications or accomplishment means. I think we fleshed it out a little bit in some of the next slides. So next slide, please. All right, so here's a complaint that we received that we reviewed within the last year, and it was a use of a video, and it was an elected official promoting discussions with residents. The video was scripted, taped, and edited, and promoted on official government social media. And I hate to say that you'll know it when you watch it. But I mean, this particular video, right? It was clearly more skewed to political self-promotion rather than an effort to address matters of public concern. It was really scripted and produced in such a manner that it looked like a campaign ad. It was an elected official interacting with the public, but it just looked like a campaign ad, and it really wasn't addressing issues of local governance. So next slide, please. But by the way, these are from specific cases, and they're not meant to offend anyone. And that's why I certainly left out the names of the elected officials that were involved in these. So for example, some of the messaging contained in these local government produced videos or other formats that were used to communicate speech. So one of them would be, so an elected official is in a video that is being distributed widely, includes a quote that I feel very comfortable using the skill set that I have and my judgment to weigh the concerns that are expressed in my community. Well, that's perfectly reasonable, right? You want elected officials that believe they have that ability, that actually have that ability. But how does that relate to local governance? right? That's more a comment that you would include in political advertising, right? Or another one. I always felt like I was a voice of reason, that I can look at both sides and all sides of the issue, and I can add value to a discussion on how tourism tax dollars are spent. Well, certainly you can talk about how tourism tax dollars are spent in your municipality or in your county, and talk about it and talk about what your position is on that. I think that would be an appropriate use of local funds. But when you're talking about how you're the voice of reason and how you can personally add value to it, I think it becomes self-promotion, and you run afoul of the ethics ordinance. Or the last one, and I remember this one in particular. So it was an elected official, had his law degree in the background, I guess like I have, right? And it says, I'm a very analytical person, and I think that my experience as a zoning professional is going to be a great assistance to the town. Again, talking about your personal qualifications for office, it's comments like this that are self-promotion, I think we're going to conclude are going to run afoul of the ethics ordinance. Yeah, certainly appropriate political speech, but not speech that can be communicated using local government resources. Next slide, please. Okay, so sometimes the job becomes more difficult for us at the Ethics Commission, right? So where you have a public official that is responding to a critique of his or her performance, right? And sometimes, the critique may be contained, in a blog post by someone that's critical. It might be contained in an article. It might be contained in political advertisement by an opponent. And so, the public statement, in this particular case, we looked at a response that was communicated by a staff member for an elected official. And the public statement was overwhelmingly a narrative that contained a factual response regarding local government funding, budgets, financing, procurement procedures, and a defense of decisions that this particular elected official had made. But really, all of those comments were appropriate. Talking about why a particular budget decision was made, talking about how procurement decisions are made, explaining the process, explaining the rationale for doing it, at least in our opinion, was entirely appropriate. There were some little comments interspersed in the response, which again have that kind of self-promotion flavor. For example, in this one, it said something like the elected official was never a man of power or fame. Specifically, a specific rebuttal to something that was said in a political ad, or describing some of the video that was included in the political attack ad as being outrageous and slanderous, right? So, if the comments are negligible, or, small comments that are interspersed within a much larger communication that is talking about local governance, I think we'll be okay. But again, those types of comments are always going to be problematic. Next video, next slide, please. Okay, so what is permissible? So again, I think that the only guidance, those of you that work in the local government or that are advising local government officials, the only guidance that we can provide is to recognize, right? There's an inherent right for an elected official to communicate with their constituents, right? Regarding public issues or for the purpose of soliciting their input, as long as there's no overt political message in the mailing and no pending political election, right? So again, overt political messaging, personal, statements about personal qualifications or self-promotion are going to be the problem areas from an ethics enforcement perspective. Next slide. All right. And like everything else, right? So what we have encouraged, local officials or those folks who advise local officials is to just use simple due diligence, right? So, so regarding an incumbent candidate, or an incumbent candidate that's seeking higher office, if you can articulate or you can show that there was some due diligence that was engaged in, that you made a best effort to avoid any blurring of the lines, then I think that you're going to be ahead of the curve on whether there's an ethics violation or not. Next slide. All right. Again, just another, just more examples of some of the guidance that we've provided, right? So messaging should not stray from a very legitimate public purpose. So as long as the message remains faithful to its public purpose, then use of an elected official's name and title and his public role, or the use of his image in the messaging, will not violate the ethics code's prohibition. So what we've seen during the pandemic, and Mayor Gilbert was talking about it, is a lot of what we in the Ethics Commission have come to refer to as kind of branding, right? So it is messaging that is produced using local government resources, clearly designed to talk about local governance or services that are being afforded, to constituents, particularly right now where a lot of folks are out of work, food drives, face masks, things like that. And it goes out, but it also has a photograph of the commissioner and his or her title included, or it says, please join me while I'm doing this, right? So we have generally taken the position that that kind of branding is acceptable, as long as the thrust of the messaging, again, is related to local government services that are being afforded to constituents, particularly during this time of the pandemic. Next slide, please. Right. So for example, these were scenarios where local government is communicating with the general public and encouraging them, to fill out their 2020 census. There was a resolution to that effect. I think that everyone would agree that this is a legitimate government function for local government to get their constituents to respond to the census. It's going to impact, financing for that local government in the future. So is it okay for that type of messaging that is being put out using government resources to have, the photograph of the commissioner, for the commissioner personally encouraging, constituents to do that, the commissioner's photograph? And we've come down on the side, again, that type of branding, as long as it is, it's not excessive and it's related to a purely local governance function, that we're going to be okay with it. It's not going to run afoul of the ordinance. Next slide, please. So this was another example. So we had this messaging using local government resources that's pushed out, hard copy, using electronic media, and this was to provide folks with free face masks and encourage them to use the face masks to prevent the spread of the disease. I think that this was actually focused to more elderly residents that might be at greater risk of serious harm from infection. And so again, we were okay with some of the branding. So the face masks were sent out, and it was accompanied by a letter from the elected official saying, "Hi, I'm the elected official. These are donated masks that were given to us by another agency. Please wear them. It helps prevent the spread of disease. If you have any questions, you can contact my office," right? So again, a little bit more personal branding, but I think we're still going to lean on the side of, this is essential communication. This is appropriate use of communicating a local government messaging, even though it has a little additional personal branding in it. Next slide. All right, so I'm going to move now from from Section G of the Ethics Ordinance to criminal violations that might arise in these scenarios. And I'll try to some of the comments may be flavored by the 2.5 decades that I spent as a local prosecutor. I certainly can't speak for the state's attorney's office anymore, but based on my experience, I think that these comments should be well received, right? So Florida's Little Hatch Act, which is located at Section 10431 Florida statutes, and it talks about an elected officer or employee, may not directly or indirectly command or advise any employee to contribute anything of value to the person for political purposes. And the reason I think that is relevant, it's really more for elected officials who are using their paid local government staff to generate messaging and to send out messaging, right? And I think the danger in these scenarios is when you are directing your local government staff, to send out messaging that is purely political or campaign oriented and has less to do with local governance. And I think that there is a good argument to be made that if you're using your local staff in that matter, you're essentially giving directives, direct or indirect directives or command to your staff to contribute their own time, right, to engage in these political activities as part of their local jobs, right? So I think it's not only is it dangerous from an ethics perspective if you're a local elected official and you're using local staff or hard resources to communicate political messaging. I think it also becomes problematic under Florida statutes where you're using your staff and you're using your staff's paid time, while staff is on duty, are getting paid by local government to get this messaging out. Next ordinance, next slide, please. Right. So again, I think the best advice for local officials and those who are advising local officials in this area is that officials should be very careful when they're directing staff to make public statements on their behalf or generating or distributing public statements or generating messaging, irrespective of the format that you're using to get that messaging out. You should be very, very careful and make sure that this is messaging that is appropriate, that talks about local governance, and that is not self-promotion or purely political campaign speech. Next slide. Okay. So I think that the danger in this area under Little Hatch is even made more serious when you have staff, as elected officials often do. You have your elected staff that is working you have your paid staff that is working for you as government employees, that they may be involved in public communications, they may be involved in generating, local governance messaging, but they're also working on your campaign, right? There's nothing that prohibits your staff from working on your campaign, from volunteering on your campaign, and for supporting you. And as a matter of fact, that's relatively commonplace. And in past lives, I've been involved in that role also. But I think that you have to be even more careful, right? When you have local staff involved in messaging, in generating messaging, in distributing messaging that is relating to local governance, and that local staff is also working on your campaign, and the lines start to blur, and I think that's when local officials start to get themselves into trouble. All right, next slide, please. All right, so I drew these from a few examples. Some of these are in Dade County, some of them in neighboring counties. So when you have government staffers and they're generating content for your government sites or communication, right? Be very, very careful what you do with that content, right? So you send it out on your, Village of Robert Myers website. I mean, that's fine. Now when you have your government staffers and they're cutting and pasting this material and sending it out on your campaign websites, right? Or when you're giving your campaign staff access that is not otherwise provided to the public to your own government website so they can collect material and repackage it and send it out, as political communications. I think that, again, you have to be very, very careful, because you're going to find yourself in that scenario where there is a blurring of the lines and you have your campaign staff generating content here for you as an elected official, repackaging it during the daytime, and then posting it on your political sites. Again, I think that you're using staff in a manner that may violate Little Hatch and may violate the ethics ordinance. Next slide, please. All right. So clearly there's a prohibition against any local employees from engaging in political campaign activities while they're on the clock. Next slide, please. All right. So a lot of times local government officials don't really think of the general theft statute as being applicable. I know that at least the local state's attorney's office has used the theft statute, to analyze this type of conduct, right? So just remember, if you're the elected official and you're using your government staff for political purposes during the day, then, your staffers are stealing time, right? And the theft statute, the criminal theft statute, has been used to address those scenarios in cases in Miami-Dade County. Next slide. All right, so that's a same comment, right? And again, just because it's your staff it's staff that's doing the work, if they're being directed by the elected official or by a senior staffer, the elected official or the senior staffer is likewise liable for that conduct. Next slide. Okay, so best practices. So sometimes when Robert and I lecture together, or when I partner with our local elections department and we talk to candidates or elected officials, I think the best practice is to be very, very clear and specific on the front end, right? So if you're an elected official and you're running for re-election, you're running for higher office, I think the best practice is to give very specific oral and written directions to your government staffers at the beginning of the campaign. Give them very specific guidance and actually reduce that guidance to write it and keep it as a record, so that later on, you can explain, if you're the senior staffer or the elected official or the person that's giving them guidance. Now, we explained all of these things. We gave specific guidance. It's a good practice because, again, it's a blurry area, and a lot of local government employees that are working in this area are not going to be able to see the distinctions, right? Another piece of advice that we give is to give a script to local government staffers. Your government staffers that are going to be answering calls, that are going to be responding to the public, that are going to be responding to media inquiries, that may be responding to political opponents. Give them a specific script of what they should say, right? Don't leave them free to, to kind of ad lib the responses that they may be providing, and so that it doesn't become, a defense of your political record, right? Give them a specific script on what they should say, what constitutes a response to inquiries on local governments, and what is really more response to a political questioning or an attack, and who they should give those calls to, right? Give specific direction regarding government versus campaign messaging, and again, just at the broadest macro level, make sure that they regularly use their personal leave, to engage in political activities, so that there isn't that blurring of the lines, and you don't get caught in a situation where your on-duty staffer is engaging in political campaign functions. So I think that's it for me. Next slide. Yep, that's me. So if you have any questions, I'm happy to answer them now. I don't know if there are any there, or you can reach me.
Jose, let's wait until we get through all the presentations. Okay.
Thank you.
Okay, very good. As always, Jose, an excellent presentation. And those who live and work in Miami-Dade County, thank you for your service as the director of the Ethics Commission. I know it's you do yeoman's work, and this time of year, given the elections and everything else, you must be overwhelmed with requests for investigations and requests for opinions. And I know the size of your budget, and it's not big enough. We can talk to Mayor Gilbert about that when he becomes the county commissioner. Okay, so I'm going to speak about sort of trying to reconcile open government and social media. And so if we can go to my first slide, Linda. So I guess before I get into that, I just want to pick up on two things. One that Jose said, he was referring to the county ethics code when he was talking about misuse of public position. And keep in mind that for those of you who don't live or work in Miami-Dade County, the state has an ethics statute as well, and there is an exploitation of official positions section in the state ethics statute. So what Jose was referring to at the local level would apply statewide if you were in a different county other than Miami-Dade. Now there, it's a little trickier in that to prove misuse of position, you have to show corrupt intent. So it's a little harder to prove misuse, but it does exist, and it has been used by the State Ethics Commission against wayward public officials. The other thing I would add is that a number of counties across the state also have ethics ordinances. For example, Palm Beach County has an ethics ordinance, and almost every ethics ordinance, whether it's a county ordinance or a local ordinance, has a misuse provision. I guess the other thing I'd like to say about social media before I start, the discussion of sunshine and public record is to recognize that not everybody has access to social media, and not everybody uses social media. Not everybody's comfortable with social media. So therefore, even though a lot of us who are more sophisticated and educated use it regularly, we have to be mindful of the fact that many in our society don't use it. Therefore, some of these open government laws sort of, respect the fact that not everybody may have access to these sort of tools. So we have to be cognizant of that when we notice meetings and things of that nature. So let's talk about the Sunshine Law first. And I guess, we've all, it's been drilled into your head, what the purpose of the Sunshine Law is. And that is that if you're going to discuss public business, as a governmental body, as a local governmental body, whether you're the elected board or a member of an advisory board or a quasi-judicial board, if two or more members of the same board want to discuss their board's business, they have to do it in an open meeting. And the part that's always difficult for me to sort of wrap my head around is it's hard enough to understand what's in front of us, what's on our agenda. It's a lot more difficult to predict what could come before us. I'm not, last time I checked, I couldn't predict the future. So I don't know what's going to come before us, but the test is it's a gathering, formal or informal, of two or more members of the same board on something that's in front of us or something that could come before us. So if that's the case, the meeting has to be held, in the open, COVID notwithstanding, and we shall see what happens October 1st with, government meetings, but I'm not going to really comment on that. We have to give notice to the public, and we have to take minutes of what's said at these open meetings. So clearly this applies in the context of social media messaging. The idea of communicating through social media doesn't make a difference, whether we're communicating over the telephone or through text or through email or writing letters to one another, or we're commenting on each other's Facebook posts or blogs. The Sunshine Law would apply. Next slide, please. So I have a couple of, if you will, brief case studies for you, sort of to illustrate the point I'm trying to make. A case in 2011 involving a Miami Lakes council member who was criticized for using Facebook in a manner some constituents thought violated the Sunshine Law. So what happened here was the elected official asked his friends on Facebook, on his personal Facebook page, to contact another council member to support a measure that he obviously was sponsoring that would prohibit council members and the mayor from serving on citizen committees. So it really doesn't matter what the issue is, but this was something that the town was going to act on. So one of his friends on Facebook happened to be another member of the council. And not only was this person a friend of his, the council member responded directly to these posts, and he indicated his support for the initiative. Well, now you have a discussion and agreement on Facebook. Last time I checked, Facebook is not considered to be, within the context of what a public meeting is under the state of Florida. So both council members were criticized for tweeting in violation of the Sunshine Law. So I guess the point, that I've sort of made already, but I'll make it again, is that the platform is irrelevant. Twitter, Facebook, Nextdoor, Instagram. If you're communicating with another elected official on your board, or if you're a member of an advisory board, you can't have these conversations outside of a public meeting. Next slide. Another case, more recent one, more local, well, maybe not more local, but certainly more recent, involved the city of Miami Beach. And I don't know if any of you have ever traveled to Miami Beach, but you see these welcome signs, which are a big deal in the city. So there was a city discussion item at a city commission meeting in 2019, and they were discussing, welcome signs and how much to spend on them and what they should look like, the design, etc. So these signs, were of interest to the city, and the city was going to spend money purchasing these signs. So clearly this was a matter of public business in the city of Miami Beach. So after the meeting, a commissioner went to Facebook to continue the conversation to criticize the proposed design. And a second commissioner jumped into the conversation regarding the entrance sign. So the question is whether this violates the Sunshine Law. All the elements are there. This was discussed at a public meeting. Then after the public meeting was over, where there had been no resolution to this particular item, a commissioner took to a private, social media platform to continue the discussion on this very item. And a second commissioner jumped in and was participating, interacting with that first commissioner. No question about it. Violation of the Sunshine Law. Next slide, please. So this is the question that I get a lot. There are a lot of people want to play lawyers, and there are a lot of lawyers out there. And some of the people who come to me with these statements, and not just me, but other municipal lawyers, we want to be advised, by elected officials and sometimes, learned government employees that one-way communications do not violate the Sunshine Law. So there is no prohibition against such communication. So if I post something on Facebook or I tweet or I put something in a blog and it's just something for me and I tell other people not to respond, it doesn't violate the Sunshine Law. And I would completely agree that one-way communication, and it's not a per se violation of the Sunshine Law. However, we have to look at the nature of the one-way communication. First of all, is it informational? That is, there's a report that you read that you want to share with your colleagues. Let's say that you're thinking about, banning plastics, and you read this report and you want to share this report with others on the commission. That's, I would argue, informationally based and maybe is less problematic than where you're actually articulating your position on the issue. So if on top of posting this particular report or circulating the report, you also offer your position on Facebook about this matter, even though you're telling the other elected officials, don't respond to this, I'm just telling you how I feel. Well, what you're doing is you're creating an environment whereby, one, you're chilling the others from responding because they know if they do respond, they're violating the Sunshine Law. But secondly, it's almost, it's something they may want to respond to. I mean, if it's something controversial or you've stated your position. So it's really important to sort of avoid the one-way communications on social media if you can, especially if it involves a matter that is going to generate a lot of buzz or has generated a lot of buzz in your community. So if you are going to do a one-way communication, even if you're going to issue this report or circulate this report to others, it still should be maintained as a public record. And you can't sort of substitute that sort of one-way communication with action at a public meeting. Action at a public meeting requires discussion and dialogue. It should not be preordained, how things are supposed to turn out. Next slide, please. Okay, so, Abby has talked about this, and the mayor has, and Jose to an extent, about, using things like Facebook or coming up with a public page. And it's the same thing, and once again, just sort of to reiterate it, that the idea is that if the city decides to have a Facebook page or they want some sort of social media presence, what involvement should the elected official have, with respect to commenting on city business. And it's, there is a fine line here, and I think we've all sort of expressed that or acknowledged that a fine line exists. We want, officials and employees to speak on public business, but not to exchange ideas with each other if you're elected officials. So if I post something on the city's Facebook page about a pending matter in front of my commission or council, another elected official cannot respond. And even to the point of where they give some sort of tacit approval, where they don't actually verbally say, I agree, but what if they like your post? So is liking a post the same as essentially, having a conversation? And I would argue it probably is the same. it depends upon the nature of the post. And let's say if this post covers city and non-city business, maybe it's not clear what the person is liking, but I would take the position that if this person is indicating that he likes my post and I have posted something about city business, then that like is a response. It's responsive to my post, which means it's an exchange, which to me would violate the Sunshine Law. So, you know, clearly we should be putting things on our Facebook pages if we have them, or other, you know, platforms that government use that should be in connection with the transaction of official city business. And Jose's talked about this, that really the things that don't belong on our Facebook pages and our other platforms if they're sponsored by the government. But we have to acknowledge that occasionally there will be ancillary information that people put on their, you know, on a city sponsored page. And then it's up to the Ethics Commission and others to analyze whether or not, you know, the key was to communicate public business or there was some other intent there. Now, the other part to this, which Abby has alluded to and the mayor alluded to, is the public records component. So we have to address that as well. Next slide, please. Okay, so going back to 2009, so now 11 years, so this might have been the first AGO dealing with Facebook. And what happened in this particular AGO, the request came in about the city maintaining a Facebook page, and it included information about friends who were posting and their friends' respective Facebook pages. So the question is all this information that's on the city Facebook page a public record? And the AG could not conclusively decide, you know, whether or not it was. They said it's very fact specific. I think Abby alluded to fact specific a few times. A lot of these things are, and it's not a lawyer's response that it's fact specific. There's such nuance here that you really have to delve deeply into this. But as a general rule of thumb, you know, if you're posting something on a government Facebook page or a government page, it probably is a public record. So the most value that came out of this opinion, at least in my estimation, was the advice where the AG said, look, government should post a warning regarding the application and implication of public records law on your Facebook page. So essentially, you're almost posting at your own risk. If you're going to comment on a city Facebook page, you know, understand that in large part that is going to be considered to be a public record, which means there are certain rules about retention that have to be followed. Next page. So if we are posting things on a government site as a public official, as a public employee, those social media posts, those blogs, those communications with public records. Okay, and I'm not going to spend a whole lot of time getting into what a public record is, but essentially everything under the sun that's made or received in connection to city business, you know, is a public record. And there are exceptions, which I'm not going to get into, but understand that if you violate the public records law, if you can't produce such records, then there's the possibility of personal and criminal liability. And there's an old case from 2009 that's part of my presentation about a fine of $770,000 that the city of Venice had to pay because the clerk couldn't produce all emails that had been requested. Let's go to the next slide, and I'll show the application of public records. So what we're concerned about here is the records that are posted, the comments, the interaction that occurs on a government site. We should have that covered. You know, we should automatically be able to back that up. You know, that our government servers have that information. So the issue of retention should not be problematic for the social media sites that the government maintains. However, what about the private platforms? How do we deal with officials and employees who post on private platforms, whether it be Nextdoor or Facebook, or they tweet, or they use Instagram? The problem is that we in government have no control of their records retention policies. It becomes our responsibility, if we're going to post about government business on a private platform, it is our responsibility to make sure that those records are retained. And I'm not going to say that you cannot post, on private platforms about government business, but if you do so at your own peril, because if those posts are deleted and somebody makes a public records request, your defense cannot be, well, we had no control over it because we don't control the records retention policies for Facebook or Instagram or Twitter. That's not a defense. And we've seen a lot of Nextdoor communications lately. I've been getting lots of questions about Nextdoor. And also keep in mind that these sites have their own policies about what they keep, what they allow. So a lot of this stuff goes outside the enforcement ambit of the Ethics Commission and the State Attorney's Office. In some cases, it's really up to the if you will, the Facebook police. They're the ones who decide what's appropriate, what's not appropriate, and may delete posts, even if the government would otherwise think that the posts are acceptable. But my point is that if posts are being deleted or comments are being deleted on a private site, and these comments you are making as a public official, and they're made or received in connection with your government's business, you have that responsibility to ensure that those records are maintained for the appropriate period of time. Next slide. Okay, so my last, I guess my last slide has to do with a resident who tweets or responds to a comment on a government or elected official social media page, but later deletes it. Is this a destruction of a public record? Abby sort of touched on this a little bit about, sort of deleting, comments. Well, like I say, I would make an argument that if a resident tweets something and a resident responds to a comment that you have made, but later deletes it, I think you could make an argument that that could conceivably be a public record. Certainly the comment by the elected official is a public record, but what about the response? So we got to be very careful about deleting public records, because if we do, as I say, you could be subject to criminal liability for doing so, not to mention fines and attorney's fees and things of that nature. So with that, I think I'm done with my presentation. I guess what I'd like to do now is to, I guess there is one other area, I'm sorry. Quasi-judicial issues. So when you're sitting, in your capacity, as an elected official or someone on a planning and zoning board, we're hearing a matter which impacts people's due process rights, which are considered quasi-judicial. You are supposed to act like a judge, okay? So the question is, can you go on social media sort of offering up your position on this item, before the hearing? Well, could a judge do that? And the answer is, of course not. So you can't either. That's different from when you're acting in your legislative capacity, where you want to comment on, say an agenda item, and irrespective or notwithstanding the Sunshine Law issues, you feel compelled to comment on something legislative in nature. Like I say, you want to adopt, a ban on plastics in your community. I would argue that the rules are different than if there is a hearing, involving an application for a variance. There, if you are tweeting or posting about the applicant or about the application, I'd argue that you're not providing due process to the parties. So you do not want to be perceived as having made a decision even before you review the evidence. So I would be very careful if I were an elected official to post comments and tweets and blog about any matter that's quasi-judicial in nature that's before my board. So I think with that, I finished my presentation. So why don't we do this? Why don't we move to, we have some time, so why don't we take a look at the questions that have come in post Mayor Gilbert. I think we were at question 10. I don't know if the panelists have had an opportunity to read them, but I'll start. The first one, it says, legally or public official social media pages, designated public forums, or limited public forums. that may be something for Abby if she wants to tackle that question.
Yeah, and I think that question came in from Roger before my presentation.
Oh, okay.
So hopefully I sort of covered that in a way that I would hesitate to sum up in one sentence without all the context I provided before. But yes, sometimes if you are presenting in the official capacity, you're presenting an issue related to that official work, and there's open comments. Yes, at least 2 federal circuits have deemed the comment section to be that portion of it to be a public forum.
Okay. Next question. Well, sharing your slides, we did. How does this apply to vendors? Example, vendor posts a negative comment on BLM, Black Lives Matter, goes against the mission agency. So to what extent do these rules, if you will, that do exist out there apply to government contractors?
I think that's talking about, because it came in during my presentation, I think that's talking about the First Amendment rules. So my first
Right.
question in that scenario would be not a First Amendment question, but is there a contractual or statutory basis to for your relationship with a vendor to take action against them? Because unlike an employee, you need to know that you have the ability to do that based on this type of conduct. So that's not really a First Amendment question. Assuming you do have a right to take action against the vendor in that respect, from a contractual or statutory perspective, then a similar First Amendment analysis would apply, which is you're now the government still, and you're taking action against a vendor who's sort of similarly situated to an employee in that you're able to take this action against them. And then you would need to say, okay, if it's about a matter of public concern, which in this case, if it's a public comment about Black Lives Matter, it probably is a matter of public concern. And then you would have to show, has there been actual disruption? You'd have to be prepared to make that evidentiary showing that there's been actual disruption.
Very good. Next one. Jose, were you going to say something?
No.
Okay. Would accepting a governmental paid stipend towards an employee's personal cell phone change the standard for personal social media posts generated by that phone? Either one of you want to address that? I have some thoughts on that too. But.
Yeah, from a First Amendment perspective, I don't think it would be a huge factor, but there are other issues which maybe, yeah, Robert or Jose, you want to talk about using your work phone for personal use. But from a First Amendment perspective, the standard would probably be the same unless there was, and it says the posts were generated by that phone. I mean, you know, I guess this is somebody who logged into their Facebook account from that phone. But unless there was some outward facing indication to the public that this was some sort of official post, I don't think that analysis would change, but this person may have violated other policies or ethical rules by doing that.
Yeah, so Jose, let's talk a little bit about that for a second. The idea of, so the government is paying a stipend, or they're essentially giving you a phone to use as in your position as an elected official or a high-ranking employee, and you use that phone, you know, to deal with personal business, and in this case, maybe even posting things on your personal Facebook page. What are your thoughts about that?
I mean, I would go back to, you know, it's nuance, right? So the latter statement that you made, I think, is easier, right? I mean, if the government owns the phone, right? If local government owns the phone, then you shouldn't be using that. You should not be using that phone, you know, for purely political messaging, and unless the provisions for the local government allow it, you really shouldn't be using it for personal use either, right? I mean, unless the local government says, here, it's a government provided phone, you can use it for personal, you know, for personal calls. But even if that's a scenario, I don't think you should be using it for pure political messaging for your boss or otherwise. If it's a paid stipend, you know, I mean, I'd like to say that the answer is the same, but I think that's kind of a fact specific analysis. I don't know exactly, you know, what that means, that it's a paid stipend. I mean, I know that in the past, I have advised elected officials, they've asked that, and they say, you know, the government, you know, I have it's my own phone, and I get reimbursed for it. Can I use it for during an election cycle? And, you know, can I use it for, you know, everything that I would use my phone during an election cycle? And what we have advised people formally and informally is have 2 phones, you know, have the campaign get you a phone, use a campaign phone for, you know, for campaign purposes or messaging or whatever it is that you're doing. and then use the phone that the government reimburses you, for personal or work-related matters. But I mean, I'd really have to look at whether it's a stipend or what that means.
Well, I think there's also a public records component here. So somebody makes a public records request for your phone records, and the presumption is going to be that if the government either gave you the phone or they gave you a stipend toward, the payment of whatever the full cost of the phone is, there's a presumption that all those communications posts would be public records. Now, that doesn't mean that they necessarily are. So you would have to go through it and essentially provide, the request with those posts and those calls that are public records. But just because something appears on a government issued phone, it doesn't necessarily make it a public record. But like I say, the presumption is that everything on those phones should be related to the government. I think there is some sort of de minimis exception. I don't know if Jose would agree with that, but there are times where, even though the phone is given to you in your public capacity, that there are emergencies that occur in other situations where you only have one phone, so you sort of intersperse, public business with private business.
And I know that there's a couple of city attorneys that are sitting in on for this presentation, and this could be the subject matter for a whole different presentation. And again, I think the general rule is if it's public communication, it doesn't matter who owns a device or what device you're using, it's a public communication. And if there are public records generated by that, then you're under an obligation, to retain those public records and to make them available upon demand. And I know that this is very, very difficult, because it not only, people, it extends to tweets, it extends to messaging. There's all sorts of public records that are generated, and yeah, I don't, if it relates to governance, local governance, the operations of local governments, whether it's stipend or not, if you're generating public records, you've got to keep them and turn them over.
Yeah, I think Abby pointed this out, and I'll just, like I say, underscore how important it is. I mean, you have to have a social media policy. I don't care what agency you are, public or private. It's important to have a social media policy, and I think that best practices that Abby outlined are critical. It's something just like you have an HR policy, or you have a public records retention policy. I don't know how in 2020 you don't have a social media policy which covers as many of these contingencies as possible. And Abby's point about, and I'm not using her word, but monitors. You've got to have people who are educated, knowledgeable about scanning your government's social media platforms. And if you have a tough call about whether something can be removed or not, I guess that's where you have to reach out to your city attorney or to the First Amendment experts like Abby. So Abby, this next question is directed at you. This person's a city commissioner. I have bi-monthly Zoom meetings inviting any citizens, especially the citizens of my district, to discuss projects that are active in the city. One individual is loud, out of control, and disruptive. I mute just him. This is problematic for me as the host of the meeting.
I love this example because it's kind of that middle ground between the two scenarios we've talked about before of the difference between a city commission meeting and a Facebook comments. This has got elements of both. So for sake of argument, I think we can assume, although it might be a close call, whether these Zoom meetings are the commissioner acting in his official capacity. Let's assume they are. If so, I think you would have a good argument. Now, could you get sued? Yes, anybody can file a frivolous lawsuit if they want to. So I'm not saying there's no litigation risk here in doing that. And I would want it, probably you would want to keep records of the reasons you've done this, that it's not because this person was critical, but rather they were out of control, disruptive, and didn't allow your speech, which let's say for sake of argument is government speech, didn't allow it to be heard and didn't allow others to be heard, more similar to the decorum you would have at a city commission meeting in your case. That it becomes more gray when you're talking about social media comments and somebody says something irrelevant, because is it really disrupting everyone? Is somebody putting a comment really preventing someone else from putting another comment? But this, as we know, in a normal Zoom context, if somebody's shouting, you cannot get business done. So I think you'd have very strong arguments that if you can prove, if sued, you can prove that this person was preventing you from conveying that government speech, I think you would have strong arguments for that, but you got to be able to back it up if it comes to that.
Very good. What if two or more board members attend a campaign forum together? They're all running for office. They intend to share their platform. How should they handle? Well, I guess one question I would ask, are these incumbents? And if you're talking about sharing their platform, if they're talking, I would assume their platform involves things that are happening in their community or things they'd like to see happen in their community. And that to me suggests that that could be a potential sunshine law problem. So if you're going to hold these candidate forums where you have incumbent elected officials who are participating in the forum, you need to notice them. You need to treat them as public meetings. So you have to make sure that once again, post-COVID, they're open to the public can attend, the public, that it's recorded and so forth. So you're acting consistently with the sunshine law. If there are no incumbent elected officials who are part of the forum, then there's nothing to be terribly concerned about. Now, if the question is, and maybe this is something for Jose, they intend to share their platform, if that means sharing it on their social media site, what would you suggest there, Jose?
Are they incumbents or are they not incumbents?
Let's assume that they're incumbents.
Okay, so I would change it, right? So what you have is two or more elected officials, right? And they're attending a campaign forum together. I mean, so just my knee-jerk reaction is that, and I'm assuming that they're talking about policy matters relating to local government and matters that are going to be reviewed by them, by their commission. I just, the entire thing makes me feel very, very uncomfortable just from the get-go. I think it's a recipe for sunshine law violations. You got three incumbents or two, or two or more incumbents, and they're talking about their local town, and they're going to be invariably talking about, matters that are going to come up before the city commission. I mean, I would, for incumbents, I try to avoid it altogether.
Yeah, so I guess what I'm asking you on top of that is, so let's say that I'm an incumbent and I want to share, I would somehow do a live feed of this forum, on my private, on my private social media page. Is there a problem with that in your view?
I mean, so they're not using any local government resources whatsoever, and they're doing a live feed of it on their private social media.
Mm-hmm.
Feed, right? I don't see that there's a problem, at least not from where I'm sitting.
Yeah, I would agree with that. Okay, the next one is, can I simply post information from a committee I chair to update the residents on, say, the most previous meetings highlights? I guess the most important, highlights from the previous meeting. I don't mean to paraphrase what the person said. Is there anything wrong with posting information about what happened last night if you're sitting on a committee, you're chairing a committee?
No.
Seems okay, right? Any either one of you want to comment on that?
Sounds fine. Be prepared for negative comments and the awkward decision of what to do about them is all I would say.
And the mayor certainly, made a point of that. Are these Zoom chat comments and questions being kept as public records? The town and cities need to keep the Zoom chat comments as public records, and the answer is, if it's connected to a public meeting, absolutely. The chats are public records, if in fact the comments are related to the government business. If they're not, I'm not sure why you would post anything, but assuming that they're tied to the meeting, they are public records, they have to be maintained. The next one, do you have an opinion, given the governor's order on virtual meetings expires in a day, whether a quorum in person can meet with remaining members virtual as COVID-19 is still an emergency or an extraordinary circumstance? I'm not going to address that one. Do either one of you want to comment on that?
That's a municipal attorney question, I think.
Yeah, there are lots of very bright minds working on this very question. We don't really know what's going to happen. Some cities have already made decisions. Some cities have passed resolutions saying the way they're going to operate. But I think the jury is still out as to what will happen on October 1st. Okay, do we have any more? Does truth in government and Florida sunshine laws apply to elected official comments inside, for example, a town gazette? So a town-sponsored newsletter or newspaper. Is it conceivable, Jose, that truth in government or the sunshine law could apply to the comments by the elected officials?
I think the truth in government might apply, and I'm assuming that they're referring to the provisions of the Citizens Bill of Rights, which are in the county charter here in Miami-Dade County, which is the only thing that we have authority for. I can envision a scenario where if you're affirmatively making, misstatements relating to local governance and in a town gazette, that it might implicate the Citizens Bill of Rights, truth in government section. I think so. Would you agree?
I would agree. And I will also say whether it's the town newsletter or a private platform, I mean, if you have two elected officials communicating, conversing with one another, on a social media platform, it implicates the sunshine law. What about use of the town seal used by elected official and mass email used in marketing capacity to drive readers to personal branding website through provided web link? I mean, I guess the general question is the use of the town seal by elected officials.
Right. So that to me is kind of a fact-specific question also, and I would defer a little bit to the municipal lawyers, but I know that that it is not unusual for municipalities in their code of ordinances to have limitations on what you can use a city seal for and what you can't use a city seal for. So it's a little bit out of my area.
Mm-hmm.
But I think it's a good idea to look at your code of ordinances to make sure you're not running afoul of the limitations on use of the seal.
Well, and there, it's, the state law, prohibits the use of seal, unless it's for a government purpose, unless you get the consent of your government board. But then local governments can go further than that. The other thing I would add, that I seem to get a lot of questions about seal versus logo, and we're not going to wade into that right now, but there is a difference. Here's a question, and I'm not sure how to answer this, so I'll ask Gabby if she wants to respond. Do you have an ethical opinion on cyber libel and the weaponizing of social media as it relates to the behavior of elected officials and free speech regarding their written words?
Well, I've certainly thought about libel a lot when it comes to whether content can be removed from a page, because to some aspects of libel, including cyber libel, will not be protected by the First Amendment. But making that determination outside of court of law, whether you have social media designees and good First Amendment counsel, drawing that line between what gets deleted and what doesn't based on, an out-of-court litigation of whether the statements were true, for example, is asking a lot of your counsel and your staff and your city or county attorneys. In terms of, but I think this question is asking more about the context of elected officials who are spreading false information. And I mean, there are certainly ethical considerations with that. And obviously they may also be violating state civil or criminal, libel laws, which would be most of which, at least in Florida, have been upheld against constitutional challenges. So yeah, they would be subjected to those. Those cases are very hard to prove, but sometimes they make it easy for people.
So here in Miami-Dade County, we have an ethical campaign practices ordinance, and there are mandatory provisions and voluntary provisions, and they do prohibit certain types of knowingly false malicious attacks on your opponent. So and as a matter of fact, I'm not sure whether we have a couple of cases in the pipeline right now. I mean, we're getting close to election day, but I can envision scenarios if there are knowingly false statements made, to attack a political opponent, where that might implicate the ethical campaign practices ordinance here in Miami-Dade County.
Abby, let me ask you this, and I don't mean to put you on the spot, and if you can't answer it, that's fine too. But we had a question earlier about I think a committee chair wanting to muzzle, a boisterous member of the public, and you offered your opinion on that. Does it make a difference if one elected official wants to mute another elected official because that other elected official is out of control? Is the standard any different?
I guess it depends on what the other elected officials, what role he's serving in. Like, what is the context here, right? If is this a public meeting? Is this?
Let's assume it's a public meeting where one official doesn't want to hear from another elected official, and then I guess you get into what's the content? What is the other person saying?
This
Right.
comes up more often than you might think, Abby.
Yes. Well, yeah. So you're basically saying the chair maybe
The chair is basically
is
muting another
silencing.
elected official for content reasons. Now, I don't know what content means, but I guess is the standard different than muting, like I say, than muting a resident or member of the
Probably,
public.
yes, because most likely in that scenario, if this is an official meeting, the one being silenced is probably speaking in his or her official capacity. So that probably is not speech as a citizen, most likely. If this is a regular public meeting, that's probably not going to be deemed to be speech as a citizen. It's the Garcetti exception, or the, for lack of a better term.
Okay.
Not exactly the Garcetti exception because it's an elected official, but that same concept of speech by, it's like the Kerrigan decision about when you're voting, you're speaking, not as a citizen.
Okay. Well, I think we've run out of time here, and I guess just to wrap it up, Jose or Abby, you have anything you'd like to add before we close down this webinar?
No, just thank you so very much for listening. Thank you for your courtesy.
Yeah, thank you. And thank you, Robert, for putting this together. I wish I could see everybody's faces. Is the only thing that,
Yeah.
at least I get to see you guys, but
So
hi to all the participants.
So if you have any follow-up questions, and I don't, we got to most of them, our email addresses are available. And if you want a copy of our Facebook presentations, we can make them available to you. This thing is being recorded. So if somebody wants to watch it again or send it to other people, you do have a right to get the recording. And we thank you for your attendance and the good questions you asked. And hopefully we can do something else like this in the not too distant future, because social media and social media communications is, I think it's just the tip of the iceberg. There's so much more that's going to happen in this arena over the next 5 to 10 years. So with that, I think we'll sign off now. And thank you very much, Abby and Jose and Mayor Gilbert, for being such wonderful panelists.
Thank you.
Thank you, guys.
Bye-bye.
Bye, everybody.